Good afternoon, everybody. This is Lisa Speaker. It is March 26, 2020, and we're here today to talk about parenting time during the COVID-19 crisis. And today I have a superior panel of presenters to help me out, starting with Judge Janice Cunningham, Eaton County Circuit Court, who does the family law cases among other types of cases, but she was a longtime family law practitioner before joining the bench. We have Connie Thacker, who's a family law specialist in Grand Rapids at the firm of Thacker & Slight. And we also have Matthew Kabliska, and I'm sorry, I can't remember the name of your firm, it's kind of long, but he's over on the east side of the state in Oakland County. Thank you all for joining us today. And I just wanted to just say a couple of things before we jump into the conversation. Obviously, we're in a very unprecedented situation, and a lot of us, or all of us who practice family law, are getting calls from our clients, not sure what they're supposed to be doing or what they can do. And so I think what that was what generated the idea for doing this is because we're all getting those calls, and there's been discussions on the listservs. There's been lots of different viewpoints. Where obviously things are changing every day. We're getting updates from the government on an almost daily basis, and things are changing for our practices, which is going to impact how we handle our clients' cases with respect to especially parenting time. So with that, I wanted to point out that everybody except the panelists should be putting themselves on mute. I guess the videos aren't bothering me that much. As long as they're not bothering the panelists, I'm fine with the videos being on. There's a raise your hand function. But really, if you have a question or comment, you can hit the chat button and send a message. And then I will try, as our panelists are discussing some of the topics, I will try to monitor the chats to see if there's something that we need to share with the group and maybe have our panelists answer, because I'm not expecting them to be able to review the chats while they're talking. And I am going to try couple of polls. We'll see if it works, but I did set them up in beforehand. So to start off with, let's start with a poll. And my first poll is, hold on a second, let's see if I did this correctly. You should have a poll show up on your screen. Connie, can you confirm you see a poll on your screen?
I see it.
There's two questions. If you could answer the two questions. And how do I answer?
Yeah, same to deny. Oh, you're a client.
I don't know that it gives me an option to answer. Okay, I don't get to answer the question. And it looks like, see, I can quickly see about half of the people have responded so far. I'll just give it another 10 seconds. And everybody who is not a panelist, if you could put yourself on mute, please. Okay, it looks like we got enough answers right now. We're not quite finished, but we're going to end it at some point. So it looks like over half of us have had calls from clients to let us know that the other side has denied parenting time. I mean, my office, even though we only do appeals, we've had at least 4 clients contact us about this. And I'm guessing that the trial attorneys have had even more calls than we have. And the second question was, have your clients been asking if they can deny parenting time? And more people had responded that call has come in. So can everybody see the poll results that I just shared?
Yes.
Yes.
Okay, good. All right, so I'm going to close that poll out. So really the first topic is, how do we advise our client when they call us to tell us that the other parent is denying parenting time? And I wanted to start the conversation off actually with Judge Cunningham because she has some thoughts about the essential functions of the court, and like just to start off the conversation about how we should be looking at our cases and the client situations. Judge Cunningham?
Thanks, Lisa. The analysis has to start with Governor Whitmer's executive order from March 23rd, and that we're referring to as shelter at home. And her order is clear and succinct. We are only supposed to be leaving our homes and doing things that are necessary to sustain or protect life and conduct minimum basic operations. So that's the umbrella of which we have to operate under, necessary to sustain or protect life. Then we have the administrative order from the Michigan Supreme Court 2020-2, which was from March 18th, of which they gave us guidance on what are essential functions. And it breaks it down by category. So for family law practitioners, we are supposed to consider and be able to handle ex parte relief for the safety and well-being of a litigant or a child. There's other things that don't pertain to parenting time, such as arraigning people within 48 hours on a felony warrant, having someone available to still record into MISIS, and doing income withholding orders and medical support orders. But for purposes of this conversation, we're talking about parenting time. And there could be a big discussion among this group about whether the denial of parenting time is in fact an essential function. But I don't think parenting time would raise to the level of necessary to sustain or protect life unless the issue regarding parenting time has to do with a parent or a child being exposed to the virus. I think all judges would agree that if there was a situation where a child has not been exposed to the virus and following a current parenting time order would place that child in danger, then as a judge, I'm going to hear that case. I'm going to either have them come in, because I would consider that an essential function, but I would first try to do that by Polycom or Zoom, whichever way that I could do it. But I've noticed on listserv the discussion, and most people I think have it right. People have to obey court orders. And the only way to deal with this issue is to file a motion to change the parenting time order. Self-help is never a remedy. And I would advise clients to not use self-help, that if they really believe that this is a matter of safety for the child or safety for the parent, I suppose that could also apply, then that would fall into an essential function. But just a disagreement about what parenting time could be because the kids aren't in school or mom and dad aren't at work, that is not an essential function. And therefore the governor has ordered that is not something we are required or should be doing unless we can do it remotely. And I think every jurisdiction is doing their best to see what they can do remotely, but we can't force litigants or attorneys to do it remotely if it requires them to leave their home or their office to do it if they don't have the mechanics of it. And I think that's what Judge Boyd issued some direction. He is the new state court administrator. He sent out a memo about 20 minutes ago and essentially saying, try to do things remotely. We need to move to do more court things remotely, but we can't force litigants or attorneys to leave their home and come to court unless it falls within an essential function. So that to me is the parameters that people should be operating under.
Thank you, Judge Cunningham. So turning back to the question that I started this off with, and I apologize because I got ahead of myself by not starting with Judge Cunningham. What do we do? I'm going to turn this to Connie and Matthew. When our client is calling us because they're not getting their parenting time, what's the advice? What's the process that you are suggesting attorneys use?
Connie, you want to start?
Yeah, sure. We've already seen this happen twice. I got a call yesterday from someone who was denied parenting time, and it was an Ottawa County case. So we reached out to the Ottawa County friend of the court to see if we could file an ex parte motion with respect to that. And I think you really have to analyze the facts as to what's going on. And so this one was just an outright, we're not going to produce the children just because of the virus. No one in either household was affected, and the kids were still going back and forth to their relatives' houses and to friends' homes, but mom did not want the child to go over to dad's, and they sort of used the child as a weapon. so that they can avoid the parenting time and use the virus. So I think we really have to caution our clients, particularly those who are trying to deny the access, is there really needs to be a real legitimate reason and risk of harm for denying that. And those that are not getting the parenting time are probably going to have to see if their county will entertain an ex parte motion. But I think what happens, even with a lot of these cases, particularly when we have high conflict cases, the parents forget about the kids. And the kids are emotionally distraught over this situation. They don't know if their parents have enough money to take care of them. They don't know if they're going back to school. So their anxiety is super high. And to take them away from one parent because of this issue just creates a further emotional strain on the kids. And I think that that's something that we as attorneys need to indicate to our clients. I mean, they have to think, I know everybody doesn't want to have their kids or their families infected, but it also has an extreme emotional impact on the children.
Pat?
You know, it's interesting. I had always thought that to instruct a client to disobey an order of the court was an ethical violation. And I searched the ethics opinions, and there isn't really any ethics opinion that takes that position, nor do the rules of professional responsibility. There is some cases, Schoency versus Bennett being one of them, in which an attorney was sanctioned for $14,000 for instructing his client not to obey an order of the court. So the bottom line is we have to be very, very careful because on one hand, we really cannot, should not be telling our clients to violate court orders. On the other hand, can we instruct our clients to put their children in harm's way? And you know, the way that I've explained it to people that have contacted me about this issue is, look, you have the legal aspect of this, have the parental aspect of this. The legal aspect clearly is that court orders must be followed. On the other hand, if as a parent, someone has a legitimate concern that the child would be put at risk, and it better not be something like, well, I saw him cough during the exchange, or something of this nature. It better be something good. If the parent is willing to risk being held in contempt because they feel that their child's well-being is at risk, then that's a decision that they can make. But I don't think as attorneys we should be advising them to do one thing or the other.
You know, it's interesting, Matt, because is it any different than, I mean, it's different because it's affecting so many more people all at once, but like if you suspect or have information that there's abuse going on in the other home, you're advising your client maybe to call CPS and take other actions or file an emergency motion to prevent the parenting time from happening if there's an unreasonable risk of harm for transferring that child. It's really no different in this situation, except that it's just a little bit more difficult to access the courts with the shutdown and everybody starting to work remotely, many of us for the very first time. I think that turns us to the next question is, and some of it has been touched on a little bit already, when a parent calls us because they think that parenting time should be denied, the child's in my home, I don't want to send my child and put them out there in a different household. So the question is for our panel, what should the parent consider before denying parenting time?
Well, remember, if you have a court order and you're asking a judge to change that order without hearing from the other side, you have to say that irreparable injury could take place if the judge doesn't sign it. It is a very high threshold, extremely high, and one that I think most of my colleagues, we only sign few of them, but I then have expedited hearings so I can hear from both sides. I mean, it's a very, very high legal threshold to ask a judge to change an order based only on what's in a verified motion with an affidavit from one side. We haven't heard from the other side. So we have to be, as certain as we can be, boy, if I don't sign this, irreparable injury could result, so I better sign it. So that's the first analysis that the attorney has to make, is what evidence can I give a judge that would be the basis to change an order without hearing from the other side. And equally important for the attorney, are the facts that my client are telling me true? Many of us, and I'm putting on my private practitioner hat, have had egg on our face where our client has told us something and we have acted on it in good faith. And then when a hearing is actually held, when all the facts come out, if our client didn't lie, at least they embellished. And I think as judges, we understand that attorneys do the best they can to do their due diligence, but at times a client might embellish or pull one over on someone. In times like this, the attorney really has an obligation to verify the facts as best they can, what the client is telling them that supports this irreparable injury, this emergency of such great magnitude that we should change an existing order without hearing from the other side. And I would further suggest that even if you think you have that, if you know the other side had been represented by an attorney, I would let them know, because obviously we're talking about existing orders. So the case could be ongoing, but most of the orders are probably a case that is closed and now they want to change the parenting time. I would find out who the attorney was, at least that represented them before, and give them a heads up that you're going to be contacting the judge to ask for the order to be changed.
Well, and I think we're also seeing some of that. I mean, we had a case recently, to the judge's point, about checking the information, where mom at the early outbreak took the kids to Ohio and then had her family physician write a letter indicating that she was exhibiting some of the symptoms, which was, a low-grade fever and a cough. And she kept the kids and refused to turn them back. Well, come to find out, she really did not have the virus, and she was just trying to use that as a way to keep the kids. But I think that people are very fearful, and they are taking extreme steps. And most of them, if they think that someone is infected, or if they're just a parent who's trying to manipulate the situation, if they're keeping the kids, most of them, I find, don't really care if they're going to be held in contempt of court. This is more important than being held in contempt of court. And so they're just sort of doing what they want to do.
So if we as attorneys, have this obligation to confirm that the facts that our client is telling us are true before we put it into a motion, like, how are we supposed to confirm that somebody in the other household is COVID-19 positive, or that they're exhibiting symptoms which are indicative of COVID-19? I'm just trying to figure out realistically, how are we going to be able to find that out for purposes of having confidence in the motion that is filed?
Well, I think that, whether or not there's a positive testing and you've got the results of the testing, or the client is actually signing an affidavit and we're saying that this is the best due diligence we can do under the circumstances. I mean, it's hard to really, without going in there and looking at them to see if they're exhibiting signs or symptoms, which none of us are going to do. But I do think, if they're going and getting tested and there's a positive test result, then that's one thing. But, you can have this sometimes for 2 weeks before the symptoms even, come into being. So it's really hard to tell what to do. But I think in some of the lower density populations, you have less problems. I would suspect in Wayne and Detroit, where we're seeing the majority of the cases. I mean, Kent County is probably the most on the west side, but we're seeing very few in Ottawa, very few in Muskegon, and I haven't seen any yet in Allegan. So we're not seeing a lot over here on this side of the state, but everybody is still under, the same lockdown.
I'm seeing a lot of questions posted right now about interstate travel. And I think one of the themes I'm seeing, because we do know that interstate travel is allowed for purposes of exchanging a child for parenting time. But I think some of the concerns that I'm seeing the attorneys express on the chat are that some parents aren't divulging where the child is coming from, for example, if they came from New York, but the other parent's not willing to communicate and be upfront with the other parent about where the child had been. And I don't know, if Matt, if you have any suggestions for trying to get the information that we need for a parent and an attorney to evaluate whether parenting time should be denied or whether a child should stay put regardless of who you represent.
Well, I mean, I think air travel is a particular problem. So it would depend upon whether, I think if a client is going to make the parental decision to deny parenting time, they'd better offer some alternatives if they're going to avoid being held in contempt. For one, offer extended make-up parenting time for when this executive order is dismissed. Offer Skype time daily, or some other Zoom or whatever platform they want to use. I think if they offer to drive and meet at a halfway point, I mean, if we're talking about the distance between Michigan and Pennsylvania, maybe that's something that could be accomplished without putting the child in the air travel system. But I would certainly make sure that the client is doing all of the right things if the client is making the parental decision not to allow or not to return the child or comply with the parenting time order.
So if the parent who's withholding the parenting time is not agreeing to allow, and we see this come up in our cases all the time, where they're not allowing the video conferences with the child on a daily basis. I mean, is that at that point that justifies a motion? It may not be an essential function as Judge Cunningham described it, but it certainly doesn't mean that you can't file a motion and get it before the court and have a video hearing on it, correct?
Well, it depends on where. Sure. Over the past couple of days, I've talked with Judge Kathleen McCarthy, Chief Judge of the Family Division of the Wayne County Circuit Court. I've also talked to Presiding Judge Mary Ellen Brennan, and the procedures are very, very different, but it's going to be very, very difficult to get any kind of court determination out of Wayne County at the moment. What they consider to be essential are matters in which one of the parties is incarcerated or PPO hearings, things of this nature. But they are not they're not accepting motions at this time. You can call a number and your inquiry will be directed to the emergency judge who's on staff that day. The judges are all assigned different days in which they have to be in the courthouse. And you call the emergency number, and that number is 313-224-8796 for people who practice in Wayne. And then they will determine whether or not your situation constitutes an emergency.
I have a few people who are on the line that if they are listening, they can unmute themselves because I might have a question to ask them. Judge Van Allsburg, who is the president of the Michigan Judges Association, I believe is on the line, as is Tim Cole, who works with the Friend of Court Bureau, I believe, at the State Court Administrative Office. And if either of you have any input about these issues, we'd welcome to hear from you while we're discussing all these issues. So one of the things, so just interrupt me if you did hear me and come onto the line. One of the things I've heard, like hypothetically, if one parent, let's just say the custodial parent is a nurse or a doctor and is going into the hospitals, is that a reason to send the child to the other home, or for the non-custodial parent even to withhold parenting time during the crisis because of the risk of exposure is so much higher for those hospital workers, or I guess a grocery store worker or other people who are still seeing the public on a regular basis? Connie, do you have any thoughts about that?
I think it's like with anything, it really varies from case to case, and what really is the exposure. And I think just what happens is you have parents that are just a little bit too hyper vigilant about it. And if they've got to take their kids back over to dad's house or mom's house, mom happens to be an ER doc, well, you would hope that those parents would be civil and sane enough to say, maybe don't bring him over here, and why don't you keep him or her for a while, because I'm going to be in the hospital and I may be exposed, and make those sort of, you know, grown-up decisions like parents do. But unfortunately, in our line of work, we don't deal with those kind of clients. So I think it's really on a case-by-case basis, and it's use your best judgment. And, you know, I think over here on our side of the state, you can still file those motions, and they'll be conducted, I would suspect, by Zoom or by telephone conferencing or whatever they need to do. But I wouldn't tell a parent not to file it. I mean, I hear what Matt's saying about Wayne, and you're probably not going to get in, but if I've got a parent that's being denied parenting time, I mean, that could be indefinitely. I mean, we could see, you know, we're at the end of March, and what the dad's not going to see their kids until the end of April. I mean, you know, that seems a bit harsh to me. And let's not, you know, as I mentioned this before, I think it's really important to remember is these kids have their own trauma from not having constant and regular contact with their parents in such a, you know, a strange time. They don't understand it themselves. I mean, we don't, and we're stressed. So imagine them. So I just think that, you know, hopefully these parents will start to make these decisions. But again, I think you're just going to have to file the motions and see if the court's going to hear it. It's going to vary judge by judge, county by county. We see that all the time, even in judicial rulings. We could have one case presented to Judge Ackert, and I could have another case presented to Judge Feeney, and they come up with different rulings. And we see that all the time, and this isn't any different. We're just going to have to file those motions to protect the clients.
I see Judge Van Allsburg took himself off mute. Do you have anything to add, Judge?
Sure. Thanks for the invitation, and thanks for hosting this. I'm just going to quote from Tom Boyd, the new SCAO administrator. He sent an email out to all the judges this morning. He's been on the job for 4 days, but he wrote a good letter, and he said, please continue to do your best to balance these many complicated factors while complying with Administrative Order 2020-2's instruction to limit court activity to only essential functions, but also to conduct other court matters remotely using video conference technology. So judges across the state most of us have had experience using the technology that we have to, for example, arraign inmates who are in jail without having them transported to the courthouse. We're now in a crash course to learn how to use this technology to conduct remote hearings in addition to those. So I do have contempt hearings coming up for denial of parenting time, and they will be held on Zoom within the next couple of weeks, in fact. I would point out, as others already have, that the governor's executive order excludes compliance with court orders, stay-at-home instruction. So parents are expected to follow court orders with respect to parenting time. That includes transportation, and it's not limited to transportation.
I should turn off the regular house.
I'm not requiring people to take kids on airplanes at this point.
Thank you, Judge. I wanted to also bring on for a second Tim Cole from SCAO, and I don't know if you have any additional insights to share with us right now about where the various courts are around the state to enable us to get our parenting time motions heard.
Well, Lisa, thank you for sponsoring this. I think this is very useful for attorneys, and I don't know if there's any friend of the court staff on here.
There are a lot, actually.
I will tell you that my colleague, who's also on the call, Amy Lindholm, and I have worked on an FAQ that's going out to the courts that deals with trying to answer the most common questions FOCs and courts are receiving about parenting time and what should happen during the outbreak. And what I'm hearing today from Judge Cunningham and everybody else is consistent with what we have in the FAQ, that people should follow the court order. If there's extreme circumstances, then they need to consider the safety of the child. We also encourage in the FAQ that parents try to work together for the best interest of their child and make decisions that are in the best interest of their child. But what I'm hearing today, again, is consistent with what I think will be released by the front of the court bureau and SCAO very soon.
Tim, is that going to go out to like all attorneys, or is that specifically just for the friend of courts around the state?
It'll be placed on our webpage, and the courts will know about it, I think, through our bi-week or through our distribution. But you should keep an eye on it for that will be coming out soon. We're going to have one on parenting time. We're going to have one on child support too, because the friend of the courts are getting asked a lot of questions about enforcing parenting time during these circumstances.
Thank you. Well, we have a lot of good questions coming from our audience. And one example, actually several people raised the issue of oftentimes non-custodial parents will have spring break as a holiday. And here we are right during the time when kids are usually on spring break. I mean, I don't know that the answer is going to be any different if the child is in the custodial home and the custodial parent's not willing to transfer the child in violation of court order. I think that parent, either the non-custodial parent needs to file some sort of motion to enforce the parenting time, or they're going to have to get make-up parenting time in the summer. I don't know, Connie or Matt, Judge Cunningham, if you have any other thoughts on that.
Well, yeah, I think you're going to see, a need for make-up parenting time. And I think Judge Van Allsburg, said as well, I would see no reason under the current situation to be putting kids on airplanes. I mean, most people have canceled their spring breaks. I mean, I've got a client who owns a travel agency who has her hands full with everybody canceling everything, but that doesn't mean they can't be over at the other parent's house during the week that we're all, sort of quarantined together. So I suspect going to see some make-up parenting time, and it better really be, I would think if, I'm not a judge, but if I were a judge, I would think that you better really have some legitimate reasons to have denied that parenting time other than I just didn't feel it was safe. I mean, that there has to be some infection over at that other house or other kids that may be infected. I mean, it just can't be scared, so I'm not going to send them over there. I mean, I think that the governor was clear about that.
I think it's an interesting point, Connie, and I know there's been some discussion on the listserv about it. Like, is it an unreasonable risk of harm to send a child from one house to the other? My only comment is, without any special analysis of the facts, just like what you talked about, it's also a risk of harm to go to the grocery store, but yet all of us have to eat. And so regardless of which home the child is in, somebody's going out from that household to get food, or food's being brought to them. And somebody, like, we're coming into contact. Yes, we're sheltering in place. We're limiting the contact dramatically compared to what it was 2 weeks ago, but it's still not impossible to completely isolate a child, even if a parent is using that as a basis to deny parenting time. Matt, I think you're about to say something, and then after Matt, I think Judge Hegarty might be on the line, and I was going to invite him to comment as well. Matt?
Well, there are a couple of things. I practice out of Wayne and Oakland, which would probably be the two more populous counties, and they're approaching this from a much different perspective. And I certainly want to say at the outset that Judge McCarthy and Judge Brennan are tireless public servants, and I'm not saying that to suck up because they're not on this. They're on the list of participants here, but they really have been phenomenal. Working day and night to try to address the problems that have come up. But Judge McCarthy did say a number of interesting things. So we're talking about Wayne County now. So if you don't practice in Wayne, this might not be all that relevant. But they can't do pro-cons at this time. They hope to expand that in the future. Probably not going to be looking at ex parte orders, routine, preserve assets, maintain status quo. Not going to be looking at those. You can file by mail, but you're going to have to be patient. It could take a while before it's processed. The front of the court will process uniform child support orders, uniform spouse support orders, and the FOC is completely caught up at this time with both of those. As far as remote hearings go, there's nothing official at this time. Some of the Wayne County Family Court judges are, using Zoom and alternatives to have hearings. The problem is that Zoom, for example, is not compatible with the Polycom system, and there's certain standards that judges have to comply with. to make a record on appeal, et cetera. The clerk's office in Wayne County is kind of an entity unto itself. They don't really answer to the court, but there should be a minimum skeleton staff there to collect checks and accept emergency motions. Mailing case initiation documents is okay. Include a check, include a self-addressed stamped envelope, but there may be a delay. Same thing with responsive pleadings. You know, you're probably okay not filing documents without labels at this time because they don't want you to come in and get labels. What she had asked is that she begged for everyone's patience during this time. Be open, you know, if there's an issue and both sides are represented by counsel, be open to a reasonable resolution of the issue. She was of the belief that the legislature is working on an emergency bill which would suspend the non-retroactive modification of child support rule. So that if you filed within a certain number of days after the governor lifts the emergency orders, the executive orders, then within a certain amount of time you can have it retroactive back to the date of reduction of wages or layoff or whatever the case may be. With regard to Judge Brennan in Oakland County, they have a formal policy and then what they're doing. I mean, the formal policy is just emergency and essential services only, but they're really trying very hard to go beyond just what's required. And for cases that are e-file cases, this would be strictly DO cases. If you have a motion that is important, they will probably look at that motion and make a ruling without oral argument. She hopes to have a pro-con process started up soon, and they may also, at least temporarily, add DM cases to the e-file system. That would solve a lot of problems. She asks that if domestic violence is a problem, for instance, the fact that you can't get a pro-con hearing and get people divorced who are living in the same home and there are domestic violence concerns, she asks to inform the court about that. She's very much interested in getting those types of cases resolved. Cases may be initiated during this time period. Again, you can file by mail all pleadings, include the appropriate filing fee by check, and include a stamped self-addressed envelope.
Matt, one of our audience members, Carmen, heard that Wayne County was adjourning all hearings and trials for 60 days.
Yes.
I'm sorry, I'm sorry, did you already say that?
I'm not sure if I did or not, but that's correct.
Okay, but if you needed to get in there sooner, or if, I know what Eaton County is doing, if the parties agree to hold the hearing by video, Judge Cunningham's willing to have a hearing. And I know I think Jon Van Allsburg is doing the same thing. So it's a matter of getting both sides to agree to come on by video. Is that right, Judge Cunningham?
Yeah, and even Judge Boyd in his communication with us this morning, while we were all encouraged to, as judges, to start doing things remotely as much as we can. If either party objects, we can't have it right now. We can't, again, I stress, we cannot force somebody to go to work or to leave their home. And so he said, do it if you can, if it's without objection, otherwise it has to be adjourned. But in Eaton County, myself and Judge Maurer, and Judge Byerly has a few of these cases also. If two attorneys, or actually even two in pro per people, had any type of a family law issue that they felt needed to be addressed and they're willing to do it by Zoom, I can do it Monday, Wednesday, or Friday. You know, one thing that a lot of attorneys may not realize is the county commission controls when our buildings are open. So Eaton County is only open Monday, Wednesday, Friday from 10 to 2. those are the parameters. So like I'm doing this from my home office. I couldn't hold a hearing from my home office because I have to record it. So I could from home, you know, some attorneys will ask to have a status conference with me. They say, hey, they want to run something by me. They've only got one issue. If it's not something that has to be recorded, I'll do it on a Tuesday or a Thursday from home. But for Eaton County, we are confined to holding hearings during the time that the building is open. But I think most judges, if they can, we're all different. Eaton County is a lot smaller, so I don't face the same kind of problems that, you know, Kathleen faces. It's just apples and oranges, and their triage is significantly different. We're doing triage through the front of the court. Both Alan Schlossberg and Stephan Holland are on this, and they're going to be looking at cases to see which new filings we need to get in if it's an issue of safety for the child. And I think, Matt, that's what Kathleen was probably referring to, is if there's any aspect of domestic violence that's involved, I believe then that falls under the essential function, and it falls under protecting life under Governor Whitmer. So we could hear those during the days that the courthouse is open. Does that answer your question?
Yeah, yes, it does. So I do know there's a lot of referees from around the state. They're on the call. It sounds like at least in Eaton County, in order to make an official record, the referees are going to have to come into the office just like the judges are. I'm just curious as to other counties, Oakland County, if we could have one of the Oakland County referees or Wayne County referees unmute themselves. I'm guessing that they're going to have to be there in person in order to make a official record, a recording of the hearing. Is that correct? I see Tracy Rank. I'm going to try to unmute Tracy.
This is Kate Weaver from Oakland County. Oakland County
Hi,
Ref.
Kate.
We are, all our friend of the court office is working remotely. So all phones are being answered, voicemails are being returned. We're moving out our dockets, so folks should be getting notices in the mail. We are similarly to the other counties looking through our caseload to see what can be handled remotely. So I guess for Oakland County, you know, please reach out. Our referees are, you know, working remotely, so they have access to their emails. If there's emergencies, there's a specific email in Oakland County, clerklegal@oakgov.com, that the motion could be forwarded to get immediate attention by the assigned judge. We're processing payments, you know, so we're still functioning at a pretty high level, while there is just a couple of people that kind of rotate through the office throughout the week. You know, it is a full shutdown, but we do have most of the office working remotely at this time.
Kate, can I add one thing? I forgot to mention that you could email petitions for emergency custody or parenting time orders to clerklegal@oakgov.com. Also, with regard to PPOs, you could complete the PPO walkthrough and then email it to ppo@oakgov.com.
What about Wayne County, Matt?
Handled.
Do you know the email for Wayne County?
No, you have to, you can call the number that I mentioned.
Oh, sorry, thank you. Do you mind putting that in the chat in case anybody needs it?
I did.
Oh, good, thank you. So there's been a lot of questions. We're not going to be able to get to all of them today, but I wanted to circle back to one that came in pretty early, but we weren't talking about that at the time. One person asked, how can you be convinced that a parent has not exposed themselves or their child to the virus? You know, basically, how do we trust if the parent, you know, is saying, you know, until 14 days have gone by or whatever the incubation period is, how do we know that we can trust where the other parent has been? I mean, they might be saying that the child's at home, but the parent or other people in the household might be all over the place. If the person that asked that question wants to expand on it, it was Dawn. You're welcome to jump on. But I guess my response is that you're never going to know with certainty, and you're going to have to use some judgment. And the problem is with a lot of our cases, especially with my cases, because mine are all on appeal where somebody's lost custody. So it's a really unhappy situation. But there's a lot of lack of trust. And hopefully with a lot of the cases that Connie and Matt are dealing with and the other attorneys on here, they're not in the middle of litigation. So the problem is really when they're in actively litigation is going to have the huge levels of lack of trust. And I'm hoping that more parents than not are able to communicate with each other to not cause problems. Connie, do you have anything to say about that?
Well, I agree with you. I mean, you don't know where the other parent has been, and you're just sort of, trusting your ex-spouse to take in view what's in the child's best interest. So if mom or dad, or mom and dad, if they've been someplace that they know that it's been exposed, you would hope that they would be rational, appropriate parents and do the right thing and say, why don't you keep him or her for the next couple of weeks, just to make sure our child, who is what these parents have in common, and it's their prized possession of who they have, safe and sound. But there's no way to know for sure where that parent's been, and people lie to people all the time. So that's a tough call. I think it's going to have to be case by case and judgment by judgment. But I think if it's been a high conflict case all along and you're having this problem, I would suspect there's some lack of truth going on one end or the other.
This is Don Wheaton. I'm the one who asked the question. And basically, yes, we're in the middle of an evidentiary hearing, finished the 8th day. We've got 4 scheduled that now are going to get adjourned. And we're probably not going to finish in those 4. It's a very high conflict situation where the father, the last time he had the daughter.
Well, let's stop. Nobody should share facts.
Okay, fair enough, Judge. Fair enough. But the bottom line here is the child was put into various situations that would be considered high
no
exposure.
Facts.
I really don't think, I don't think we can talk about cases that are currently pending before any
Fair enough.
of our colleagues.
I think your point, John, was that. I think your point was that, a lot of people are in the middle of high conflict post-judgment litigation, and there is very little trust, and really there is no way you're going to know with certainty. Even a parent with the best intentions who is isolating themselves still has the mail come to their door, still has to get groceries from the store. So there's, even the best intentioned parent is potentially at risk for some exposure.
Right.
I guess that would be my point. Judge Hegarty, I saw that you unmuted yourself. Did you want to add to the conversation?
Sure. First, all the judges, all the referees, all the people from the various offices of the front of the court, thank you, attorneys, for working hard on this. These are bizarre times. We've lost a commander. Donna Faye Collins has died as a result of COVID. We have reports ongoing of various personnel within KMAC who are testing positive. Everyone has to be so very, very careful. The Michigan Supreme Court's order issued on a Sunday was utterly unique in that it granted direct authority to each trial court judge who is a state trial court judge in Michigan to do what she or he needs in this time, subject only to the limitations of statutes and the federal and state constitutions. There's a concern about an administrative order that says remote hearings can't be done while the judge is not in the courtroom, which obviously at the time was designed to prevent folks from working from home in the bathrobe instead of the judicial robe. Fundamental, basic due process of law requires that if the choice is between no hearing and a hearing where you've got folks on the phone, you do the latter. My colleagues have different systems set up. We're each trying our best to help. We are rotating a judge each day. We judges are relying on you attorneys to work very hard at resolving as many of these issues as you can, even via conference call and email. I guarantee you, people have to be patient. If there is a real emergency, we will hear a real emergency, period. If anyone has any concerns about scheduling, my judicial attorney, Patty Woodruff, put on the listserv, which I do not read and do not participate in, because I'm always concerned about even inadvertent ex parte communication. But so any of our judges, Judge X -court at 3rdcc.org, that will send an email. You have to be careful. If we are overwhelmed by underwhelming emergency motions, there will be probably consequences. I mean, I'm not going to hold it against somebody unless truly they're violating the court rules in terms of spending time on matters that are not true emergencies. You know, this situation, I expect, will get better. And a year from now, our court system will be far more efficient. You all will not be schlepping around the state of Michigan. You're going to log in and use Zoom, and we'll have court hearings remotely. People will continue to die. It's a terrible thing, but please do not trouble me with an emergency if it's really not an emergency. The lawyers need to safeguard their most valuable possession, which is their reputation. And if I get motions that are simply a waste of time, I'll still grind through them. But I have no idea what other folks in other places might do. So I have a process, Judge Hegarty -court at 3rdcc.org. Patty is working very hard remotely. But again, the word needs to spread that we will handle all the work we can, but our work in person can only be that which truly is an emergency. There is an order out there from at least one court where law enforcement is authorized to remove people perceived to have COVID-19. These are strange times. I worry about the contamination everybody worries about, but you know, our job is to help all the people and to serve them. And we're going through some bumps, and we will figure out how to do this remotely, and we will get through this. And again, first line of defense is you all deciding what truly is an emergency needing to be heard and what is not. I am open to doing status conferences. You reach out to Patty through that email I've provided, and we'll figure something out. We'll call in remotely. We'll figure out what we're doing. Those are my comments. And again, I thank the presenters at today for just an excellent job. Jon Van Allsburg has emerged as one of our great leaders. Judge Janice Cunningham as well. We're very blessed to have wonderful people. So good luck.
Thank you, Judge Hegarty. I want to call on another person. Our current chair of the family law section is on the call today, Liz Bransdorfer. And while I give her a chance to share some of her thoughts, because I think she's probably hearing from attorneys from all around the state as the chair of our section, I'm also going to launch another poll. If you can take a quick look at it, it's questions about whether you've been able to file a motion this week or have had anything heard. So I'm going to start launching this poll. But Liz, would you like to share some views with us?
Sure. Welcome everybody, and thank you, Lisa, for hosting this. I think it's amazing. I wanted to say that the State Bar of Michigan is working tirelessly and around the clock, coordinating with the State Court Administrator's Office and others to try to provide as much information as possible. In family law, we have identified enforcement of parenting time, enforcement of child support, and what are we doing about court deadlines as the three most urgent issues. And so this webinar deals with the first one. My personal perception, based on the weight of the evidence that I have seen and the comments that I have read, is to back up what I think the judges have all said and what most of the participants have said, which is you start with a presumption and a very strong presumption that if the parents don't agree to do something different, they should be complying with their court orders. If one parent believes that the other parent's home is more dangerous than theirs, they have a really significant burden to establish that the other parent's home is more dangerous than theirs. And just, you know, kind of general anecdotal information about risk factors probably isn't it. You know, if I don't want to send my child to the other parent's home because if he or she gets it and comes back, my elderly parents who live with us could be affected. I understand that, but that is something you should be able to work out with the other parent. Maybe they keep them and you get make-up parenting time because your parents or your other children are at risk. I really do think that if requests to modify or to do something different come with proposed solutions, they are much more likely to be accepted and people are much more likely to be able to work things out than if somebody starts with an I'm afraid I'm not sending the kids.
Thank you, Liz. And Judge Van Allsburg, I'm going to unmute you right now, or try to or unmute yourself, because I wanted you to share. You posted something on the chat that I think I want to make sure everybody saw. So if you could share your last comment about the detention orders.
Oh, yeah. There is in Michigan something called a public health law bench book, and that's where you can find all of the references. But family court judges are authorized by law to issue detention orders for someone who is determined to be a health risk to the public, and that would be someone who's been diagnosed with COVID-19, who then violates local health department instructions to self-isolate. So local public health department officers can file petitions in the family division, case type ID for infectious disease, and get an order to take someone into custody for purposes of either treatment or testing or detention to protect the public.
Thank you for sharing that, Judge Van Allsburg. Like I said, we had a lot of really great comments on the chat. We can't go through all of them today. It does seem that we still have some very divergent views about whether it's appropriate to exchange children for parenting time or not. And I think we're all gonna keep on obviously watching as the situation unfolds. I wanted to thank Connie, Matt, and Judge Cunningham for helping out today and sharing their views and insights. And then also for the special people that I called on it without warning you that I was gonna be calling on you, but I really appreciate all of you that attended today. And obviously we're gonna have a lot more conversations, and logistically, there's a lot of things we didn't get to today, including some more of the logistics. You know, we talked a little bit about Oakland and Wayne County. I think we need to talk more about emergencies at a future date. Obviously, child support, a lot of people were commenting about child support, and that was not the topic for today, but I think it is worthy of discussion. And it sounds like there might be some more coming down the pipeline from Scale regarding child support. So I think we have a lot of work ahead of us for all of us to protect our clients and our clients' children and ourselves as well. So thank you all for attending. I will be sending out to everybody who signed up the recording, because some of you have asked if you came in a little bit late, you'd want to go back and listen to the beginning. So we will be sending a recording out to everybody who signed up to attend. And then I think we'll probably make it available to the family law section members as well. So thank you all for attending. I'm going to keep the comments open for a while because I want to keep on reading them. I wasn't able to read them all as we were listening here. And it looks like only a handful of people have had court this week. 7 people that answered the poll were able to go to court this week, and or might have been electronically, but nonetheless had argued a motion this week. So thank you all for participating, and have a great rest of the week.
Thank you.
Thank
Bye-bye.
you.
Thanks.
Be safe.